Good to go. Ma'am, please start the recording first of all.
Okay. Good evening, friends. I, C.A. Chandrakant Kale, I am the moderator today for this webinar. It is very delightful to welcome you all on this webinar today, which has been organized by the Committee on Commercial Laws, Economic Advisory, and NPO Cooperatives. Friends, it's a pleasure to be a moderator for this webinar in the Know Your Law series. And the today's topic that we have today is the intricacies on will drafting.
Recording in progress.
Before we start this webinar, I would like to apprise you on about the committee. This committee is focused to encourage chartered accountants to shape the strategy and the policy that unlocks economic, financial, and social values while combining analytical foresight with the commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulations, to develop and publish technical guidance, background materials, and various other activities, and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Friends, today I'm pleasure to have today with us an eminent speaker on this particular topic. And I'm sure that with his enriched knowledge, whatever he is going to talk to us and share his knowledge with us, it will be very useful to all of us through his speech. It also gives me a pleasure to welcome our own CCM, Shri C.A. Chandrasekhar Chitre sir, who is also the chairman of this committee. Before we start, I would like to give a brief introduction about Chitre sir. Sir is a BCom and FCA.
No need of my introduction.
Yes, sir. Thank you, sir. So before we start this webinar, I request Chitre sir to give his opening remarks on this topic.
Yeah, thank you, Chandrakant. It's my indeed pleasure to welcome the scholastic personality, CA Dr. Dilip V. Sadbhai, who would be taking us through the topic today. Friends, ऐसा कहा जाता है कि जिंदगी के साथ भी जिंदगी के बाद भी. So whatever wealth you accumulate during your lifetime, you enjoy it the manner in which you like. That is your right. But what about enjoyment of that wealth, your assets, after the demise of a person? So will is one instrument which gives him a choice to ensure that the wealth amassed by him throughout his lifetime, whatever he leaves before he leaves for heavenly abode, goes in the hands that he likes, and those kith and kin enjoy that wealth. Friends, you should be aware that if you do not make the will, then there are succession laws which take care of your wealth, which manner you may or may not like. I'm sure the speaker would be dilating on it. But if you want to focus on your own desire for the purpose of enjoyment of your wealth, which is hard earned by you during your lifetime, or you might have inherited from your forefathers, it is necessary that we take a choice and we make a will. Now, in Chartered Accountant's office, you are habitual to have several customers, high net worth individuals, those who come for income tax returns, those who come for doing auditing, maybe consultation. So the person of first choice to ask about the will is the chartered accountant. Again, in case of a family, if there are certain persons who are aged, maybe their relatives, their say son or daughter cannot tell father that please make a will, because it would be taking a negative sign that they want something out of wealth. That's why they are suggesting. So it is very awkward. Or some persons also may feel that he is going to die. That is what the person saying to make will anticipates. Ashok. But as a chartered accountant, I am sure that as a consultant and as a financial advisor, you can certainly request your clients that if you make the will, then your property would be inherited, it would go in right hands. So often chartered accountants are called upon to prepare wills because they are the most confident. For maybe 10 years, 20 years, they are handling a particular client. So they know nitty-gritties in respect of that client. They know his family members. So the clients are more confident in taking advice of a chartered accountant. So at such occasion, a chartered accountant should be able to stand to their expectations. I'm sure understanding how to make will, what are various rules, regulations, how the law governs, what are the purpose, whether registration is necessary, not necessary, pros and cons of doing registration, not doing registration. All these aspects would be dealt with by the learned speaker. I have acquaintance with Dilip for maybe past 3 decades, and I have always been impressed by the scholastic deliberations, by his writings, and by his sharing of knowledge. He is always keen to share with others whatever knowledge he has, and he has abundance of knowledge. In fact, this webinar is one occasion that we would like on a national platform that he shares the knowledge, but also we have constituted a group which is Dilip Sadbhai, under Dilip Sadbhai, and this particular group is also coming out with a booklet on behalf of our committee that how to make a will. While it is possible for Sadbhai to make, say, 500-page book dealing each and every aspect, then if you make such a bulky book, then nobody is interested in reading it. So we will be confining it to 40 to 50 pages, so that if any occasion comes, if any client asks you to prepare a will, maybe by reading those 40, 50 pages, you would be able to do justice to the request made by the clients. So after this particular presentation, the committee will come up with one booklet, and I'm sure with that booklet, you will be able to, I think, draft the wills certainly in more appropriate manner and a legal manner. So with these words, I once again welcome Dilip for the purpose of addressing the audience. And I'm glad that Chandrakant, who is former chairman of our Pimpri Chinchwad branch, has taken the mantle of coordinating this particular session. So thank you, Chandrakant, for helping the committee in this behalf. Thank you.
Thank you, sir, for your opening remarks, sir. Very well said about the topic. Friends, today we have, as I told you, that we have a today eminent speaker with us. Before we hand over the session to him, I would like to introduce him. CA Dr. Dilip V. Sadbhai is a practicing chartered accountant and a senior partner in DV Sadbhai and Company. He was also a treasurer, secretary, vice chairman, and chairman of Pune branch of WIRC. He has delivered empty number of lectures on GST throughout India. He was also a member of Indirect Tax Committee of WIRC. He was also the member of Internal Audit Standards Board of ICAI. He was also a member of study group for government accounting and financial planning for local bodies. He was also member of Maratha Chamber of Commerce for finance, and he has written a lot of articles on direct and indirect taxes, economics, commerce, and investment consultancies and labor laws. He holds a degree, master's degree in law, and was first in the order of merit in University of Pune. And he has also successfully completed PhD in law. He has also in the merit list of our CA examinations, that in intermediate and also in final examinations. He was winner of National Merit Scholarship for several years. He has also won a Ghamandi Prize in the field of law. He has also been felicitated by our former Chief Minister, Honorable Shri Sharad Pawar ji, and also was recently felicitated by Mayor of Pune. He has also done a lot of certificate courses which has been conducted by our institute. Just to cut down short, I will just mention the numbers. Around 10 to 12 certificate courses he has successfully conducted, regularly writing articles in various journals and newspapers. He's also associated with a lot of NGOs and doing a lot of social work for the society, for the well-being of the society. Friends, the biodata is around full page and I'm just cutting it short. And if I start reading it, I think half of the session will go down, but I don't want to put it so. And therefore, on behalf of the committee, sir, I would like to welcome you on this virtual platform. Welcome to you, sir. And then I would like to hand over the session into your hands, sir. Here, over to you, sir. Any difficulty, sir?
No, I'm just sharing the screen.
Yeah.
Whether I'm visible or not, that I'm not aware of. At
No, the screen is not visible. Matlab, your presentation is not visible. You are very much visible.
My video is visible.
Yeah.
Our office can guide him for the purpose
yes.
of sharing screen. Yeah.
Yes, just let me know how it is to be done now.
Share screen. Last time you have done it, na, before we
No,
start.
no. At the bottom, there will be option share screen.
Share screen.
At the bottom. And one arrow would be there.
I have closed down that arrow.
Oh.
Because I'm myself is also not visible on the computer in itself.
No, you are very much visible, sir.
No, you may exit and you may rejoin so that all those options will come.
Should I exit again?
Exit and rejoin so that all those options will come. That is Jugaad technology.
Now this.
Now screen is visible. Yeah.
Yeah, screen is
visible. Okay.
Yeah.
My video is also visible.
Yes, sir.
Yes.
Okay. Thank you. Shekhar sir, should we start?
Yes, sir.
You can.
Thank you. At the outset, I must thank our very charismatic chairman of the committee, my old-time friend in itself, Chandrasekhar Chitale. Then the vice chairman of the committee, Prakashji Verma. Assistant secretary, Hina Gupta ji. Then Anjali Sharma ji, advocate Anjali Sharma ji, and my friend Chandrakant Kaleji. It gives me immense pleasure to be here to participate and address a topic which is not only near to my heart, but also a topic which I like very much so far as the generality of the topics are concerned. I used to teach this particular topic when I was teaching in law college for 15 years. And that is the reason why I have gained some more confidence on this particular will drafting. So today, I will be sharing this entire information in 4 or 5 groups or 4 or 5 parts. The initial part that I will be talking about the uncertain future which is there in our life. And in order to overcome that particular certain future, there is a need for everyone to draft a will in itself so that the problems in future can be minimized, reduced, because you are the only person who is known to be a karta and the other members of the family comparatively are illiterate and they are not in a position to do the thing that what normally would be doing. And that is the reason why the will is not meant for those who are living, but it is ultimately meant for those who ultimately are going to remain in this particular world after the departure of the karta of the family in itself. So in short, life is nothing mere but about planning for the uncertain future. And one of the most significant uncertainty in life is the timing of death. So it is certain that we are going to die one day or the other day, but we don't know when we are going to die. And that timing of death is very important. And since that being uncertain in itself, you need to manage your property in such a way that the property which you at present are owning go to the right hands of the legal heirs with whom you ultimately wish to transfer those particular property. Just Shekhar has said that Jindagi ke saath and Jindagi ke baad. On the same lines, I just would like to bring to your notice that life is so uncertain. It is so uncertain that no one can predict as to when a person sitting on the chair will be hanged on a wall in the form of a photo frame with a garland of sandalwood flowers around the photo frame in itself. So it's very difficult to find out when you are going to leave and when you are going to die. And that is the reason why for management and the administration of the property, you need to have a will. And then that is the reason why will becomes very useful and beneficial. Now, I straight away will go to the law point. What do you mean by the term will? It has been specified in section 2 small h of the Indian Succession Act, which means that whatever will we are going to talk about has got a source and support and backing from the Indian Succession Act formulated by the Government of India. So the first important part that what you need to know about will is that the will is a legal declaration. Whatever would be the contents, whether you are knowing law or not, that is not important. Whatever declaration that you'll be making in the will be called as a legal declaration. It comprises of intention of the concerned testator. Testator is the person who normally makes the will. It is the intention of the testator that is required to be related with the property. And the third important point that is required to be covered up is that whatever the generality of transfer of property that he will be envisaging about, that is to take effect only after the death of that particular testator. So 3 points are there in this particular definition. First is, it is a legal declaration. Second, it talks about the intention of the testator to transfer the property with an intention that his desires are required to be carried out. And the last important point is that whatever desire that he has spelled out in the will in itself are to take effect only after his death. So once these 3-4 points are covered, the document is called as a will in itself. Halsbury of Laws of England, that has also defined in the same way. German is the legal author which ultimately has also jotted down in the same sense. Now the question comes. I have given you the definition in 4 parts. So you will ask me a question. Why is it necessary to draft a will? Why will is required? So some statistics are there. In a minute's time, I will finish it off. Every day in the world, around 150,000 people are dying due to old age. This is very important. It's a finding by the report in itself, of which 1/5 die in India, which means that nearly 30,000 people are dying every day in India, which indicates that around 100 lakh people die every year due to old age in India. Then the second important point, deaths due to hunger in India is around 25 lakhs. Nearly 462 people die in road accident in India, which is a world record. From 2014 to 2021, nearly 98 lakh people have died because of insufficient medical care, in addition to COVID-19 victims. And the last one, every day 28 farmers are committing suicide, where number is more in Maharashtra state. Now the question comes, this is the fact, so many persons are dying. They are having properties worth several thousand lakhs of rupees in itself. What is to be done about that? That is the major issue. And because of the laxity shown by these particular deceased person, because either they are not aware of the situation or they are not aware of how the property ultimately is to devolve upon the legal heirs. Around the government report say that there is about 50,000 crore worth of property which is lying idle only for a simple reason that the property could not be transferred to the legal heirs. And that 50,000 crore rupees is very important price, important matter, which we need to take into account. And the second important point is that in India, as per the report, hardly 9 to 10% people are ultimately drafting the will in itself, which means that in India, out of the total population which we need, if we consider all the population together in itself, the percentage will come down. But I am considering that only those who are having wealth to their credit in itself, in that particular case, hardly out of 100%, 9 to 10% of the people are only drafting the will in itself. And if you compare this particular figure with the Western countries like USA and other Western countries in itself, then you will notice that nearly 46 to 60% of the population who die ultimately are being looked after by the will in itself. So they are drafting the will. So this is the financial literacy that I'm talking about. So this financial literacy is the major reason for not making aware of the situation or the circumstances that they are likely to follow over a period of time. Now you will ask me a query, what do you mean by the term financial literacy? Now financial literacy is nothing mere but knowing about all the assets and liabilities and their repercussions and the values, so that whatever transfer ultimately will take place, what ultimately would result into. If that is done, what are the benefits, and what is not being done, what will be the benefits in itself. I will give a simple illustration for this, and you will come to know the importance of financial literacy, which is only there in our chartered accountants community, which is practically absent in any other remaining professional in itself in its strict sense. For example, now a person is having two sons. An illustration I am giving you. One is a doctor, the other is a chartered accountant. The gentleman is having huge property worth 5,000 crore rupees in itself, and he is not aware that whether his two sons are competent enough to look into the entire matter of, say, huge 5,000 crore worth of property. So he just wanted to test the children in itself. So he simply gave 100 rupees to both the doctor and chartered accountant, son in itself, and said that I have got a money changer. You go to money changer and get me 1 rupee coin. He charges 10% commission. Then the doctor's son, 95%, 99%, 100% marks, went to the money changer and told that my father needs money. He has given me 100 rupees. Please give me coins. He said, my commission is 10%. He said, okay, no problem. And accordingly, he gave the 100 rupee note. The money changer kept 10% commission of 100 rupees. That is 10 rupees, and 90 rupees were given back to the doctor. He gave the money. Doctor's son gave the money to his father. Then the son chartered accountant left to the money changer. But while going, he thought over the matter, that why my father has given 100 rupees to each of us. Why 200 rupees were not given to doctor's son? Why 100 to him and why 100 to me? And that is the reason why he thought over the matter while going to the money changer in itself. He made his plan how the money is to be demanded, because he was aware that 90 rupees were being brought by the doctor's son in itself. So he went there to the money changer and said that I need some coin. He again said 10% is his commission. Then he said, the chartered accountant son said that I need a money, I need a change of rupees 90. Then the money changer immediately said that my commission is 10%, 90, that is 10% on 90 will be 9 rupees. So he gave a note of 100 rupees. He gave back 91 rupees in exchange in itself. So this is the thing that I'm just bringing to your notice. A doctor's son went over there, he brought 90 rupees. A chartered accountant's son went there, he brought 91 rupees. 1 rupee is not a small, big sum. That is not the issue that what we need to make it out. But if it is 1,000 rupees, amount will be sizable. If it is 1 lakh, it will be 1,000. If it is 1 crore, it will be 1 lakh of rupees. If it is 100 crore, amount will be 1 crore rupees in itself. So the father did not stop on this. He said that his sister is coming in the afternoon. He had 2 sisters. One was coming at 2 o'clock. The other was coming at 3 o'clock. He said to his son, go to the platform, to the railway station and get back these particular sisters. So doctor's son went there, but he was very honest. He went to the railway booking, said that I need a platform ticket. The concerned person said 50 rupees the charge. So accordingly, he went inside, paid 50 rupees and went inside. He saw the sister, that is auntie in itself, and brought back that particular auntie to home. At 4 o'clock, again the chartered accountant son went. While again he thought over the matter, he again went to the railway booking center and said that I need a platform ticket. He said that 50 rupees is the charge. Then he thought over the matter. We are in Pune now. Shivajinagar ticket is only 20 rupees. Even if I get a Shivajinagar ticket of 20 rupees, I'll be allowed to stay on the platform for 1 hour's time. The railway is coming within 15 minutes of time. So he paid only 20 rupees to the railway booking center and went to the platform. The auntie came, he took back and came inside again the railway station. Then he realized that ultimately what we have been done, or what has been done, is that now he has not traveled to Shivajinagar. He again went to the railway booking center and said that I have cancelled my booking now. Please return my 50% sum. So that 20 rupees ticket was again being exchanged, and only 10 rupees were the total cost of this particular chartered accountant person. This is financial literacy I'm talking about. This is what the thing that each and every person is expected to know about. Only by becoming a graduate or a double graduate or an engineer or a doctor, financial literacy doesn't come. You need to have that special feature of financial literacy, and that is the main reason why the wills are not getting drafted for one or the other reasons in itself. Now, there are other reasons also that I will just bring it to your notice also, that there are certain challenges that the concerned persons are not aware of the fact as to how the estate planning is required to be done. They are totally unaware of the fact that how estate planning can be done. They are comparatively not much literate on that particular count. And the second important point is that every day that will is to be drafted, or today, tomorrow, the day after, this goes on, because I have been experiencing this, that one gentleman is coming to me to draft the will since last 3-4 years, but he has not yet finalized. The reason is that, no, we have got some work, laziness is there. For one or the other reason, they are not coming. So this laziness is the major reason for not coming to the mark in itself. And that is the main reason which ultimately needs to be jotted down. I remember a small story in this particular context before we start our deliberations on the topic. This is the story of a school teacher and the mother in itself, that I will just explain you in a short while from now, or just now. The mother comes to the son, get up, you have to go to the school. Then the son says, no, mom, I don't want to go to school. Mother thought that the son is not happy or not getting full sleep. That's the reason why he's not ready to get up. So again, after 5 minutes of time, she comes, son, get up, you have to go to the school. Again, the son says, no, mom, I don't want to go to school. Then the mother said, get up within 5 minutes. I'm coming after 5 minutes of time. Again, after 5 minutes, she reaches. Again, the same question and the same answer. My mom, I don't want to go to school. Then the mom asks the son, why you don't want to go to school? Tell me 2 good reasons as to why you don't want to go to school. Then the son says, I am not happy with the school. The students don't love me. Teachers hate me. Then the mother retracts. Oh, these are not the 2 good reasons as to why you should not go to school. Then the son hits back. Mom, you are telling me go to the school, go to the school, go to the school. Tell me 2 good reasons as to why I should go to the school. Then the mom says, why 2? I got ample reasons to tell you, but since you are telling me 2 reasons, the first reason is that you are 52 years of age, and the second is you are the principal of the college in itself. So this is how the things are being there, that laziness is there right from the children to the principal stage, and that is the main reason why the wills are not getting drafted for one or the other reasons in itself. Many testators are not aware of the procedural requirement. Nowadays, every day, everything is possible in the Google, but still they are not attempting to look into the matter. And as a result of which, these procedural requirements and not getting updated themselves, this is normally the main reason for not drafting the will. Then normally some of the people feel that will is required to be drafted when the death comes nearby, or when they become old, or when the person becomes rich itself. So these are the misnomers which are there in the minds of these particular people. And that is the reason why, even if the persons are having property worth rupees 10,000, they should jot down the will, so that whatever property that they are having, it will pass on to the legal heirs, to whom they ultimately think about that it should go. So this is how the things are being there. That is the major thing that we need to understand. It reduces the complications. That is another important feature that I just wanted to bring to your notice. Recently only, a lady died who did not jot down a will in itself. She was having a lot of ornaments, and the ornaments were only in one category, one Mangal Sutra, one necklace, and many other bangles, etc., which were being there. But she had 2 daughter-in-laws. Now, she must have committed to the first daughter-in-law that once she got married, that this diamond ornament will be given to elder daughter-in-law in itself. But this was not known to the younger daughter-in-law, and a tussle started after the departure of this particular lady. So this could have been settled earlier. This could have been jotted down on a piece of paper, and the disturbance or the quarrel in between the 2 daughter-in-laws could have been avoided. But since this was not specifically done, though the desire of the concerned lady was sure that it was to be given to the elder daughter-in-law, but since it was not jotted down, a claim was put forth by the younger daughter-in-law that where it has been jotted down that it should be given to the elder daughter-in-law. So this is how the things, complications move. Doubts are also moving, quarrels are also moving. And if you have to put these particular things to right in itself, to rest in itself, there is no other alternative for you but to ensure that a will is being drafted. Now, there is a general FAT that I have already told you, that estate planning is a very important feature. What is to be incorporated therein? What are the ultimate things which are ultimately to be covered up? Since everybody is not very clear on this particular point, and some say that my assets are very tiny, I don't need a will in itself. So another challenge is that whenever you are drafting a will, that a quarrel normally starts in the family. That when the father is drafting a will in itself, and if you are having 2 sons, 1 daughter, etc., they start quarreling with each other. No, this property is required by me. Don't give to him, they give to her, or whatever the situations are being there. But in order to remain firm on the decision that the concerned testator will be taking, I would rather advise you to have a video recording of the will writing process. Once that is being done, a picture also should be jotted down when the will is being signed by the owner in itself. Once that is being done, it becomes unchallengeable in the technical sense, so far as the matter is being concerned. Now, the will, thus, once it is being prepared, it becomes a binding document that ultimately covers up the testator's wishes and intentions regarding the property owned by him, and ultimately in future after his departure, to whom ultimately it will be managed or who will be managing the property. Note one point, that a testator, if he is a minor, then he cannot make a will. And this will can be either a handwritten copy, or could be typewritten copy, or even a Word document. And depending on the situation now, this can be even on a piece of paper. So there is no requirement as such about the matter in itself, that how the will is required to be drafted. Contents we'll see at a later point of time. Now, if this will is not drafted, there are laws which ultimately take into action. And in that particular case, if the person happens to be a Hindu, then Hindu Succession Act normally applies. So the concerned person, the concerned testator, has to take a note of it, that if the will is not prepared, then in that case, the property will devolve upon the legal heirs which have been specified in the Hindu Succession Act in itself. Now, the major issue that what we need to understand here is that if the will is prepared, there are two types of things that you will have to look into. One is the testator succession, and the second is intestate succession. Now, intestate succession is nothing more but a succession without a will in itself. So that is how the things are required to be looked into, so far as the generality of the topic is being concerned. So brief point, that if you fail to draft a will, and you have not specified the choices where and how the property shall devolve, then this is the chart on which the property will go, whether you like it or not in itself. So will can change this particular process, and there are about 4 immediate legal heirs which are called as class 1 heir. In all, 12 legal heirs are there, but major legal heirs are 4. One is the widow, the second is son, daughter is the third, and mother is the fourth. Father do not find any place in class 1 category. So if the sons are 1, 2, 3, they will get 1 share each. Widow will get 1. Daughter, if they are 1, 2, they will get 1 each, and mother will get 1. So 1 widow, 2 sons become 3, 2 daughters become 5, and mother 1, it becomes 6. Everybody will get 1/6 of share is the precise issue that what you need to make it out, so far as class 1 category of shares are concerned. The remaining is that if the son is deceased, then predeceased sons, legal heirs come, and whatever their branch was getting the share, that will pass on to the next branch in itself. That is what the first category of class 1 heir is there. Then if class 1 category heirs are not there, it will go to the class 2 category, and there are 9 entries which have been specified. Entry 1 supersedes other entry. Entry 2 supersedes 3rd, 4th, and up to 9. Third entry supersedes 4th, 5th, up to 9. And accordingly, in short, in order of preference, the property will default. If no class 1 heir is there and father is alive, property exclusively will go to the father. If legal heir, class 1 heir are not there and father is also not there, then sons, daughter, son, sons, daughter, daughter, brother and sister, all will get share in equal proportion. And that is how the property will devolve upon the legal heirs. So this is what the rule that what I have just mentioned over here. Now there are certain exemptions which you need to understand. And these are if the marriage is performed under Special Marriage Act in between 2 different religions, Hindu and some other religion, then Special Marriage Act is applicable. Then additionally, stepchildren, either male or female, do not have rights in the parents' property. And the scheduled tribes, etc., come under the purview of Hindu Succession Act. Now, there is a change that has been made in the year 2005 that women are entitled for the property in itself. So now, the deceased person happens to be having a second wife, legally wedded after the first wife's divorce or death, she will also be considered as legal heir. Her children and the first wife children also will be regarded as legal heirs of the deceased. And also note that children born out of the wedlock also are legal heir, which means that even if marriage has not been performed, but the children have been conceived. So that also are the legal heirs. Now, in a small, brief manner, Hindu woman dies, property will devolve upon the husband and children, then to the husband's heir, then to the mother, then to the father's heir, and then to the mother's heir. So why I have been giving you this particular structure in itself or tree, that if you write a will, then in that particular case, these particular processes can be avoided, and you can transfer the property to the person of your own choice is the benefit that you are likely to get. Now, moving further, which kind of property is required to be transferred will be the next issue, which is the subject matter of our will. A person may own following kinds of properties. One is self-acquired property, which is earned by him due to earning his bread and butter, and it can be either movable or immovable. Ancestral property is a property earned by forefather, and he is inheriting the property being born in the family of those particular forefathers. Third is some third persons are giving certain property, and which is not to be used by him but to be used for others, which is a property held under trust. And the fourth category is the located, which is the property movable or immovable, located inside India and outside India. Now, while dealing with the will, you will come across of three types of certificates. One is the legal heir certificate. The second will be a succession certificate. And the third will be a letter of probate. Now, we will just in a brief manner, because this is very important, because once you die, you need to give this information to all your legal heirs, and you need to keep everything ready so far as the input matter pertaining to the certificates are being concerned. Now, the first is about the legal heir certificates and why it is required. Now, a legal heir certificate establishes deceased person's relationship with the legal heir. So when you get a legal heir certificate, you will find the relationship of the concerned deceased person with the legal heir. So legal heir was father, legal heir was husband, legal heir was mother, legal heir was son of so and so many other things. So this relationship is very important. In short, spouse, children, parents will require this certificate for the transfer of ownership rights. Then from where it is to be collected? It is to be collected from the Tahsildar in the Taluka, corporation, municipality office, or district civil court, or any other authorized body after a due inquiry. Then all eligible legal heirs are expected to obtain this certificate to claim deceased person's property, without which the property does not come to the concerned person. That is the reason why the will is being required in itself. In addition to that, the certificate is also required to process the deceased employee's pension, because the relationship is need to be established. Dues such as salary arrears, that why you are getting this salary, provident fund contribution, gratuity, etc. And the last but not the least, even for employment on compassionate grounds, that is the most important part that in government service that you normally come across of. Now, they must provide whatever is required to be provided. An application is to be lodged, death certificate is to be attached, then an affidavit on stamp paper declaring their relationship. So everything is to be given in writing, and once it is there, they will inquire with some other people, and ultimately the certificate will be issued. It's not a difficult job to get this heirship certificate, but this is required. Now, this legal heir certificate is required, as I already told you, and we need to find out the difference in between legal heir certificate and the succession certificate is concerned. So I have already told you that the relationship needs to be established in case of legal heir certificate for getting a family pension, getting a job, compassionate grounds, or transferring ownership of various movable, immobile property. But the succession certificate is required for inheriting any immobile or movable property defined in Hindu Succession Act. The district Tahsildar can issue a legal heir certificate to the deceased person's legal heir, while the civil code normally gives succession certificate to the dead person's legal heir. Now you will notice that the legal heir certificate and the succession certificate, the succession certificate has got some more important value as compared to the legal heir certificate is concerned. So you have a choice that both certificates need not be obtained. Either you can go to the legal heir or to the succession certificate, as the case may be. Now, there is a dilemma, and many of the persons are still unaware of the fact that what is the real difference in between the word nominee and the word beneficiary is concerned. Now, you might be knowing that beneficiary comes only when the matter of law is there, but the word nominee is there when regulations are there. So in that particular case, you can have a nominee for the bank's fixed deposit, bank accounts, various company shares, mutual funds, then REITs, etc. Then while doing that, ultimately you notice that these are the things which are being required so far as the nominee and beneficiary is concerned. But note one point here, that as per the Indian law, nominee is only the trustee of an asset. He is not the owner of the asset. That is the major thing that I am just bringing it to your notice in itself. So therefore, nominee or naming someone as a nominee means that this person only will be able to act as a representative or custodian. So now let us go into the details and try to find out now a normal illustration in order to understand this particular point. Now you have an account with bank. You have named Mr. A, who is your son, to be the nominee. The concerned person who is holding this particular account has 3 sons, 2 daughters, a wife. In all, 6 persons are there. But nominee is only one. One person's name is specified, elder son. After the departure of this particular father, whether son 1, that is elder son, will get the entire property? Answer is no. The point which you need to make it out is, nominee is a trustee. He holds the property in trust for other legal heirs. So the property will be transferred by the bank to the concerned nominee, and nominee will then in turn transfer the property to all 6 heirs in the instant illustration. That is what the major thing that I just would like to bring to your notice. Now, the point comes over here that you have nominated in a bank account and you have given a different name in the will that what you have prepared. Now, in that particular case, whenever there is a friction of names appearing in the nominee as well as in the will in itself, which is ultimately to prevail. And it has been pointed out in number of cases as well as in the law that the beneficiary named in the will supersedes the nominee of the asset in itself. So whether it is a unit of Unit Trust of India, unit of mutual fund, shares in a limited or unlimited company, or whether it is a case of any other bank account, term deposit, saving account, or current account, as the case may be. But note one point, will is the supreme power so far as the matter of law is concerned, and the nominee that has been jotted down in the regulation will be only considered as a trustee in itself. So note this point well, that a nominee is a trustee and the person in the beneficiary will be the real owner in the technical sense. So the problem comes when there is no will. when there is no will. And that is the main vulnerable point which we need to make it out so far as the nomination factor is concerned. Sometimes it is a blessing, sometimes it is a disguise over a period of time is being concerned. I will give you one concrete case which has happened in Pune. A lady known named as Bhagyada, her surname is also, I can make it out, Bhagyada Pandit, a successful, rich, young chartered accountant professional who was residing in Pune, named her mother as the nominee on her savings bank account, having a balance of above rupees 50 lakhs. A rich chartered accountant, Bhagyada Pandit. Everybody knows, though, who are there in Pune, they will know that who is this Bhagyada Pandit. And she was owning huge property. She subsequently got married to a well-to-do chartered accountant with whom her relationship had soared, but they never got divorced. Unfortunately, Bhagyada passed away suddenly in a plane accident. Even though her mother was intended to be beneficiary and named as the nominee on Bhagyada's bank account, without a will, as per Hindu succession law, Bhagyada's estranged husband was named the legal heir to the account in itself. So see the situation, what was being thought about, what ultimately happened. And why this happened? It is because of the non-drafting of the will in itself, because nominee is the super thing so far as the will is not there. But if the will is there, in that case, it would have superseded the name that appears in the, nominees category in itself. So that is the main thing that I just wanted to bring to your notice. Bhagyada Pandit's case is a very important case which you need to understand over a period of time and try to gauge that what can happen if this particular things continue in your life as well. And the last factor about the certificates is succession certificate and the probate in itself. Now, in India, succession certificate and probate both are being considered as legal documents, and these are required on the deceased person who ultimately will die, ultimately is required to be obtained. A succession certificate grants here the rights to inherit deed, security, etc. But note one point, that probate of will is a document that proves the authenticity of the will in itself. Now, succession certificate, heir certificate talk about the relationship as well as the legal heirs, who are the person where, what is their relationship. But the probate talks about the authenticity of the will document, and that is more important so far as the probate is being concerned. So this is how the things are which are required to be looked into. Now the succession certificate is required for movable property like provident fund, bank deposit, shares, loans, other securities, whereas rights to immobile property and other assets of considerable value require the approval of probate in itself. So that's the major issue that you will have to look into so far as the technicalities are concerned. Now these last 2 points are comparatively important, that if the immobile property is there and a letter of administration is required for immobile property like land in itself. So if the land is there and other things are there, in that case, letter of administration will be required. But note one point about the probate. This is a normal misconception which is there in every part of the country in itself, that every person who dies is required to ask for the probate in itself. That is not the case. Only in the case of big metropolitan cities, Mumbai, Kolkata, and Chennai. Mumbai, Kolkata, and Chennai, these big 3 metropolitan cities, probate is required if the person dies, is the major issue that you will have to look into. New Delhi is, even though it is a big metropolitan city in itself, is not included in the definition for obtaining a probate in itself. So of the 4 big metros in the country in itself, New Delhi is excluded, whereas Mumbai, Kolkata, and Chennai are being included. Thane is not included in Mumbai is another issue that you will have to look into, because normally people feel that Thane is part and parcel of Mumbai. That is not the case. In Thane also, no probate is required. So other than these 3 cities, if a person dies, probate is not at all required. And that is the area where advocates and some other persons who are ultimately to earn money in itself, they simply are taking the matter to the courts in itself and ultimately are penalizing the legal heirs who are illiterate about the probate matter is being concerned. So this is all that about the initial part, that what I just mentioned about. Now we are going to the characteristics of the will. What is required to be covered in the will in itself? What are the important features which we need to learn and understand so far as the various important essential features of the will are being there. Now, the first important point that you need to understand, that will is a legal document. So it has got a support of section 63 of the Indian Succession Act 1925, and you can get that properly executed and attested, it becomes a legal document. One more thing that you need to learn, that the person who is competent to make such will is expected to do the will in itself, which means that if the person is incompetent, then they cannot make. More details we'll see at a later point of time. Then simply writing the name on the document as will, it doesn't become a will in itself. It doesn't become a will. So what is being required there? It requires a testamentary declaration of disposing of the property. So this is the fundamental feature of the will in itself, that when all other things are being satisfied, there has to have a testamentary declaration of disposing the property in itself. Once that is being present, condition number 1 about the legal document about section 63 of the Indian Succession Act will be said to have been complied with, and thus it will be called as a legal declaration. Nobody can say it is only on a piece of paper, it has got a force of law. Even if it is written on a piece of paper, still it is being having that legal force. As a legal document it is being called. And the second important feature is that only those persons who are the owner of the property, only those persons who are the owner of the property, they can draft a will. So the declaration should relate exclusively to the property of the testator which he wants to dispose of, which means that after his death, how the property should go to the legal heir. If the declaration contains no reference to the disposal of property, but merely appoints a manager to manage the property, or give merely an authority to his widow to adopt, then it is not a will. So note one point, that disposition of property is very important. Only appointment for management will not constitute a will in itself. That is what the ownership point that ultimately talks about. In one case, a document was executed by a Hindu of an advanced age. In this document, he partitioned his property amongst his son, and the document was called as will. Can that or will that, was that being called as a will in itself? Answer was no. In addition to that, some few words were being jotted down. If at any time I come back from pilgrimage and find mismanagement or the character of anyone is bad, then I shall have the power to cancel this particular will. It was held that the effect of this clause was to make a document of a family arrangement rather than a will in itself. Ramnath versus Ram Naniga. So this was the case ultimately that decided this particular second characteristics, that the person needs to be the owner, and simply writing down the name on the legal document as will, it will not become will in itself. Then the third and the most important point that is required to be understood, is that the declaration regarding the disposition of property is intended to take place only after the demise of the testator, only after the death of the testator. If it is done during the lifetime of that particular testator, because the will is being made now, anyway, I'm going to die, you have it today, that will not be considered as a will in itself. So it must take place subsequent to the date of death in itself. If it is done prior to that, that is during the lifetime interviews, then in that case, it is not a will. That is what the third point, the most important point, which is required to be remembered into, that it must take place subsequent to the date of death. Then the fourth important point, that once you can do anything, as like an appointment, you can appoint any person, you can remove that person, you can terminate his services, you can suspend him. On the similar points, this revocability is also there. Once the will is being made, then in that particular case, the will also can be taken back or can be withdrawn. And the essence of the every will is that it is revocable during the lifetime of the testator in itself. A will always operates from the date of testator's date and not from the date of execution. This is another point about revocability that is required to be learned into. And the last point, which is there in the amber color point in itself, in other words, will always speaks from the death of the testator. So will come into operation only after the death of the testator is the precise point. One of the Chief Justice of India has made this particular statement, will always speaks from the death of the testator in itself. I have quoted that over there in itself. Then moving to the further, the characteristics of will, we are moving further. Now there are two types of wills we will come across of that we'll see at a later point. But there are two wills which are unprivileged wills or privileged wills. But this we will see at a bit later stage. Or we'll do it now. Now, in case of unprivileged will and privileged will, these are the two cases which you come across of. Privileged wills we will see first. Now, there are certain categories of persons who are being conferred with this particular right, and as a result of which they ultimately talk about this. But this point I will cover up later because this is getting mixed with the other points. Then the language and writing of a will in itself. Now, what kind of language that you can use? It can be Marathi, it can be Hindi, it can be Telugu, it can be Bengali, it could be Punjabi, any language that you can use. There is no specific format and there are no technical words which are required to be used in this particular context. The wording should not be ambiguous. It should be totally unambiguous so that the testator's clarity has to be there as to what they ultimately are doing. Now, this will can be either handwritten or it can be typed one. It can be in the ink or it can be with the pencil in itself. So, the English courts have held that when the will is written in ink or the testator has made pencil alteration, it will be presumed that the alterations were deliberately made in itself. So, whatever language and whatever writing that you wish to write it down, you are at liberty to do and write. There is no specific format that once you can use it. Certain points are being there with the help of which you can write on your own and as a result of which will be prepared. Now, since artificial intelligence is in full swing now, ChatGPT 3.5 OpenAI is available with everyone now, every chartered accountant, every lawyer. You can just give a information about you and you will have this will being drafted by ChatGPT as well. So that is as simple as that. It is not that difficult. You need to go to someone and get the things done. Once the ChatGPT drafts that particular will, then you can go after consulting your family members are concerned. Coming to the sixth point about characteristics of will, is stamp duty necessary for will in itself? Now, the answer to this particular question is that no stamp duty is required on wills and codicils. So, codicils are nothing mere but the addenda or amendment that has been made to the wills in itself. So wills and codicils can be jotted down in an ordinary paper. However, the civil manual says that if it has to be contested, something happens about that, it can be preferred, ledger paper can be preferred. It is required to be stitched, and more than that, in between 2 pages, you have to keep a butter paper. But that's a procedural aspect, wherein will not be considered as invalid because of the point that what have been specified. Now, registration fee is also there. Whether it is required to be registered or not, that we'll see at a later point. But registration fees are there. The registration fees with the competent authorities differ from state to state in India. And in the state of Maharashtra, the fee that has been prescribed is ₹100. So 100 rupees is the maximum cost. No stamp paper is being required. That is point number 8. It has to be jotted down on a simple paper, which is non-judicial stamp paper. So don't worry about stamp paper. No stamp paper, either judicial or non-judicial, is being required. You can simply write down on any piece of paper that is still being permitted under the Indian Succession Act. Then point number 9 is animus destandi. Now, what is this animus destandi is the major issue that you will have to look into, that whether the necessary intention to transfer the property is there or not, that is required to be looked into, and that is what is being called as the animus testandi. Once that is being there, it will be considered to be a valid will so far as the technicalities are concerned. Now, the death to give effect, that already we have discussed, so we'll not repeat that point once again. Form of a will, there is no prescribed form that has been considered. It needs only to be signed and attested. So this is very important issue, signed and attested as required under the Indian Succession Act. If the necessary animus testandi is present, even agreements, letters, bills of exchange, powers of attorney may operate, take effect as wills, provided that under such animus testandi, the dispositions are not to take effect until the person's death is concerned. Now, what is being specified here is that even a bill of exchange, this can amount to, this could be considered as a will if it is payable after the death of the person in itself. A power of attorney, normally revocable at the time of death, but once that is being there, may operate in these particular matters in itself. So, in the technical sense, the animus testandi is very, very important, is the major issue. So, there is no form of will that has been specified. You can write down any point first and any point second, any point last, any point first. That is your choice. There is no format in the technical sense, and that format, since not being jotted down, you can write as per your own choice. Then at least 2 witnesses are being required, and those 2 witnesses are the major important persons in will as will are being concerned. Each witness must have seen the testator sign. So what is the duty of the witnesses is being there? In brief manner, I will just explain you, and then we will go into the details. The witnesses are not expected to know the contents of will. I'll repeat, witnesses are not expected to know the contents of the will. The witnesses are expected to see and ensure and testify. 3 points. Have to see, ensure, and testify that the testator has signed the will in their presence. The testator has signed on the will in their presence. In addition to that, after the signature of the testator, in the presence of the testator, both witnesses have signed the will in itself, may not be in the presence of other 2 or other witnesses are concerned. So it must be in the presence of testator. The other witness may not be present, but the presentee of the testator is being considered important. So each witness must have seen the testator sign or affix his mark. There are certain illiterate testators in itself, so they can put a left-hand thumb impression. So that also will be acceptable so far as the technicalities are concerned. But only thing that what they need to see that the person has signed in their presence or put their mark in itself in their presence in itself. Then the second important point that each witness has to sign the will in the presence of the testator, although they need not sign in the presence of each other. So they may not sign in the presence of each other. Two witnesses are being there. So in that particular technical sense, they have to sign in front of the testator only. Then the beneficiary, legatee, or its spouse shall never be the witness to the will itself. So in short, the persons who are the beneficiaries in the will, the persons who are beneficiaries in the will could be spouse, could be children, could be grandchildren, or any other Tom, Dick, and Harry. These persons cannot be and should not be the witness to the will in itself. That is what the law has specified so far as the matter of law is concerned. Now, ordinarily, I have told you that wills are signed by the testator. The testator, instead of signing the will, may put up his mark, and because of his illiteracy in itself, or because of the finger itself, or fractured fingers are there, or many other reasons, or sheer habit. It can be any reason for that in itself. So in that particular case, the marking is important rather than putting signature is being concerned. So that has to be done in presence of these two witnesses are concerned. Then attestation is being required. Now this attestation is also very, very important. And that attestation is very important in the sense that they are attesting the signature of the testator for testifying the signature at the time of executing the document. It is not necessary that witness should know the contents of the will. That is what I have mentioned just now. So witnesses and attestation, these are two categories go hand in hand, and you have to look at the point from that angle in itself. Then the 14th important point about the will is you have to appoint an executor of will, that who will be doing this particular thing, because a person is having 4 children and a wife in itself. All 4 children are minor in itself. They will not be in a position to do. Wife will not be in a position to being illiterate in itself. So somebody has to be there to look after his death. And the person who looks after the property after the death of the testator is being called as an executor in itself. Normally, you have to specify the name of the executor in the will in itself. If you fail to mention the name of the executor, then the concerned minor children and the spouse, they will have to go for letter of administration to the court in itself, and then they will have to get the one executor appointed for the management and disposition of the property is concerned. So you have to be a little bit careful in jotting down the will so far as the executor of the will is being concerned. So an executor is someone who is named in the will to manage the deceased person's estate. The executor is responsible for carrying out deceased wishes and instruction, including paying off debts, whatever liabilities are there, making funeral arrangements, paying for that, distribution of assets to the beneficiary. The executor is also known as an administrator. Typically, an executor can be your known chartered accountant, the chartered accountant who is rendering you services for various tax categories or taxations in itself. He can be lawyer or any family member. But it is suggested that no other relative should be appointed as the executor because they more peep into the property rather than they take care of the legal heirs are concerned. That is the reason why only these 3-4 categories, chartered accountant, lawyer, family member, should be considered to be appointed as an executor to the will is concerned. Now, the testator who makes the will can appoint an executor. Court can appoint one if there is no prior appointment in itself. The executor may need to apply for special legal authority and can deal with the estate in itself. Now, there are certain points what the executor can do. I will just brief it out. Meeting the funeral expenses, then obtaining death certificate of the testator, interpretation of the will in the right manner, distribution of assets, drawing up an inventory, expense management, applying for probate in itself, and remaining other matters. We'll go about that at a later point. Advantages of being an executor in itself. Now, beneficiaries shall be ensured of proper handling of the property. So this is another important point. By appointing a third person as executor, the family can be relieved of the administrative responsibilities. If executor is appointed in time, it shall save time and money and shall prove advantageous to the beneficiaries. Many cases have been pending in the court due to family disputes, which can be avoided by appointing an executor who will be neutral and fair in his dealings. Now, note one point: executor not qualified being a witness, not disqualified from being a witness. An executor, however, is not disqualified from being a witness. In other words, the legatees or beneficiaries cannot claim under a will if they are witness to the will, but there is no bar on this executor, and the same person may validly be the executor as well as attesting witness as such. But in such a case, he cannot take a legacy or other benefit under a will. So point to be remembered here: executor can be a witness is the major thing that is being highlighted over here. He can be a part and parcel of the distribution of property, but he cannot get anything out of the property in itself, is the qualification that has been prescribed over there. Then point number 15, that medical practitioner certificate is also required, which is another important characteristics which is required to be remembered. Now, it is advisable to have a doctor, medical practitioner, as one of the attesting witnesses, especially in cases where the testator is old or infirm or hospitalized, or where the will is likely to be challenged after the death of the testator is concerned. This is done so that the doctor can testify, if need be, that the testator was having sound mind and understood what he was doing. However, it is observed by the Supreme Court of India, there is no rule of law or evidence which require doctor to be present when the will is executed. So only certificate is being required about the mental and the physical fitness of the concerned person, of the testator. The testator is in a sound mind and is capable of knowing what is required to be done. What he has been doing is precisely the thing that what he ultimately thought about. And once that is being done, the matter will be said to be over, so far as point number 15 of medical practitioner certificate is concerned. Now, this medical practitioner has to be normally a civil surgeon, but nowadays any medical practitioner having a higher degree, normally double graduate, is being preferred, but even MBBS also will be acceptable if the person is their family doctor in itself. Signature of the testator is the 16th important point that is being required. Now, either the testator must sign or affix his mark to the will, and the will must be signed by the other person in the testator's presence under his direction. Intention behind signature is important. Such signature or mark will be placed that it appears it was intended to give effect to the writing of a will. So why this signature is being required is being specified over here, that whatever contents of this particular will are there, these are acceptable to me, that is to the testator, and as a result of which I am putting my signature just below the will in itself. So once that is being done, point number 16 will be said to be over. Now, to this rule, there is one exception. That one exception is that testator should not be minor. Except for that also, there is one exception. It lays down that a father and he alone, whatever his age may be, can by will appoint a guardian for his minor children. In such cases, father's age is immaterial. Now, note one point, that if a testator who is a father at the age of 15, can he be considered as a major for the purposes of this particular situation? And the answer is yes, so far as the technicalities are concerned. The law says father's age in this situation is not material. But note one point, today after the Child Marriage Restraint Act of 1978, that the child marriages are now not permitted. These are not illegal. These are not permitted, which means that if the marriage is solemnized, it cannot be declared as illegal. They will go behind the bars, enjoy the state guestness over there, but ultimately will come back after a certain period of time. Marriage doesn't get averted because of the law in itself, because it's a sacrament, it's a sanskar. Once that is being performed, it cannot be taken back. That is what Hindu law theory talks about, and that is the reason why child marriages are being restrained, but they are not illegal. Then registration of will is the 17th important point, that under the Indian Registration Act 1908, there are few documents, a big list is being prepared, that these agreements, once they are being executed, these are compulsorily required to be registered under Section 17 of the Indian Registration Act. However, registration of a will is not incorporated in that particular list. So what does that mean? So under Section 18 of the Indian Registration Act, it is provided that registration of a will is not mandatory or compulsory. However, it is advisable to register the same as it has more evidentiary value in the eyes of law in itself. Some 2-3 cases are there, those I will share with you. In the case of Ishwar Dev, it was held by the Supreme Court that non-registration of a will cannot be held to be a reason for invalidity of the will in itself. So it was challenged on the ground that it was not registered, but the Supreme Court said, no, it is not compulsory. Thus, it can be concluded that the above precedent is not it is not mandatory for anyone to register the will, or it cannot be said to be invalid just on the ground that it has not been registered. In the Raj Kishore Panda's case, the will was put forth as one of the documents under Section 18 of the Registration Act, and for which registration was considered as optional. The case ultimately decided that it is optional. If you wish, you may. If you don't want, you may not, or you should not. That is what the decision that has been given in Raj Kishore Panda's case. Then Kameshwar Rao's case is being there. If the will is no adverse presumption can be drawn if will is not registered. It was also suggested that the non-registration of the will was very material circumstances against its truth, and the explanation offered for non-registration was palpably false in itself. So it cannot be a ground for challenging the will. That is what the point number 17, that's what you need to learn. Then the next important point in the will itself is codicil. Now, what is codicil? A codicil is nothing mere but it is another document made in relation to a will by explaining the contents of the will, altering the contents of the will, adding to its disposition, or modifying certain part of the will in itself. So once that document is there, that document under Section 2 small b of the Indian Succession Act is called as a codicil in itself. Again, it is having the same meaning as like that of a legal document, and it modifies, it is deemed to be modifying the will in itself, either in part or in whole. It can add, remove, change provisions of the will, but does not replace the will. So will continue to be there, and this will be considered as an annexure always at all times. Codicils are typically used when someone wants to make small changes to their will rather than creating a new will is concerned. A codicil must be executed with the formalities as like that of a will. It must be signed, witnessed in the same way. Will maker must sign. Witnesses must also be present in the same lines as like that of a will. And the codicil thus is being attached to the copy of the original will. The codicil can be used by, for a certain reason, change the executor, update the beneficiaries, update the guardianship wishes, protect beneficiaries from tax consequences, revise end of life wishes. So this is what the general thing is being there. There is no legal limit to the number of codicils a person can have. In one case, there were 102 codicils which were being prepared. Firstly, powers were conferred, then were taken back, again conferred, were again taken back. In the third case, conferred on some third person, again on fourth person. So this went on for 102 codicils in itself. So there is no bar on that. And you can have as many number of codicils as you may wish to have. So accordingly, the will is being considered in this technical sense. Note one point. This is the most important point of the codicil, that if the will is registered, then the codicil also is required to be registered. If the will is registered, but the codicil is not registered, codicil will have no value. It will be, the changes will be ineffective, is the major issue that what you need to make it out. Keep this particular point in mind. If the will is registered, codicil also has got to be registered. If the codicil is unregistered, the changes would become ineffective so far as the technicalities are concerned. So these were the characteristics of the will in itself. Now, who can draft a will is the next important point. In the next two slides, we will cover. Now, the first point that has been specified under Section 59 of the Indian Succession Act, that the person who is a person of sound mind will be called as a person capable of making a will. Now, you will ask me a query. What do you mean by the term sound mind? Now, when a person happens to be having a rational judgment capacity to decide what is good from bad, the person will be said to be having a sound mind. Now, if a person is there who is just imitating a dog because the dog has taken out his tongue out and the person also has taken his tongue out, can this person be said to be having a sound mind is the issue. And answer to this particular question will be that why he is doing like that. Is it out of fun? No problem. But if it is not out of fun, but he says that I'm copying down the dog in itself and the repercussions are not known, then he is not in a position to have a rational judgment capacity to decide what is right and what is wrong, what is good, what is bad. And that being the reason, the person will not be said to be having a sound mind. Then a person who is a minor also will be said to be incompetent to make a will in itself. Now, who is a minor? The minor definition is nowhere specified, but under Indian Majority Act 1875, the definition of major has been specified. And the definition says a person who has completed his age of 18 years will be said to be a person of major age. And when, with the administration of his state, he is being monitored by the Court of Wards under the Court of Wards Act 1890, then in that particular case, the age of majority will be completion of 21 years of age. So either 18 years or 21 years is the age of majority. And now the minority will be a person who is not of a major age will be called as a person of minor age. So if he happens to be even of 20 years of age, but his estate is being administered by the Court of Wards, still he will be reckoned as a minor according to the definition is concerned. Then a married woman can dispose of by will any property which she would alienate by her own act during her lifetime. So if the married woman has got her property under various laws, she can dispose of. She is competent. Prior to 1955, she was not, but after now 1955, she is being competent enough to do this. Persons who are deaf and dumb and are blind can make a will if they are able to know what they are doing. So again, repeat, deaf, dumb, or blind. These are the three persons which have been specified. Then a major issue that a person who is ordinarily insane may make a will during interval during which he is a person of sound mind. So note this point well. Normally, a person is half mad or full mad. What name can be given, I don't know. But the person is not of a sound mind, but there are attacks of unsoundness of mind. So when those attacks are there, then in that case, he is not eligible to make a will in itself. But when those attacks are over and now he is in a sound state of mind in itself, he can make a will. That is what the law ultimately talks about. Conversely, if a person is of ordinary sense, he cannot make a will when he is not of a person of sound mind, as when he is under influence of drugs or intoxicated. So a drunken person under the influence of drugs are said to be incompetent to make a will during that particular hours only. No person can make a will while he is in a state of mind that he does not know what he is doing. A person looks to be healthy, a person looks to be gay, person is having sound mind, it looks like, but ultimately he doesn't know what he is doing. Only by the facial expressions are different, but the mental element is quite a bit different. In that case, if he is unaware of what he has been doing, then in that case, he cannot make a will. In other words, in order to make a will, person must have a sound mind and disposing capacity. Now let us go into the details and what the courts have said about this competency. It is quite settled will that a person who is drunk or so much under the influence of the intoxicant that he is deprived of his mental faculty and or reason and understanding is void and have no effect. So a person who loses its capacity to decide or who is having an influence of intoxication in itself, then in that case, he is not competent to do that. Then a will cannot be challenged on the ground that simply the person of a habitual drunkard, unless it is proved that at the time of executing will, he was under an influence of liquor. Calcutta High Court has observed that mere ability to sign his name or carry on ordinary conversation, etc., answer familiar to easy questions, etc., does not constitute a disposing mind. So, mere old age does not disqualify a person. Mere because of old age made his memory rather feeble is no ground for nullifying a will. Where wills are made old, sick, dying person, it is not enough to show that such person was able to answer usual familiar question. It is also necessary that he was fully able to comprehend the nature of testamentary act and that he understood all aspects of the will when he signed it. So these are what the courts have said. Let us not go into much details of that, and let us go further because time is running out for me in itself, and still half of the slides are still left out. Now going to the kinds of will. What kind of will you can prepare? Now there are only two types of will which are the subject matter of Indian Succession Act. The first is privileged will, which are being made by soldiers, airmen, and mariners. And the second category of unprivileged will is unprivileged wills, which are made by other than soldiers, airmen, and mariners. So we all come under the category of unprivileged wills. Privileged wills are exclusively available to the soldiers, airmen, and mariners are concerned. Let us see about privileged wills in a brief manner. Under Section 65 of the Indian Succession Act, a soldier employed in an expedition or engaged in actual warfare, that is the person who can make a will. A soldier, then second is airman, again an expedition engaged in actual warfare, and the third is airy mariner being in at sea, provided he has completed 18 years of age. Thus a soldier while in barracks and an airman on land would not be entitled to make a privileged wills. The term mariner is a wide expression which includes all seamen from the captain to the cook, provided they are at sea. Now, what does this mean? This is what the technical feature just I wanted to bring to your notice. So only three illustrations I'm just finishing off within 1 minute time. A medical officer attached to a regiment is actually employed in an expedition. What is the rule which is specified here? The soldier employed in expedition. So here it is an expedition. He is the soldier and thus can make a privileged will. Second instance. So here he is involved in expedition now. Second is an admiral who commands a naval force but who lives on shore and only occasionally goes to board his ship is not considered as at sea and cannot make a will. Now, what is being specified here so far as the soldier is being concerned? It is being specified here that mariner being at sea, provided he has come, being at sea is the major issue, and he is not at sea, he is not considered at sea, and he cannot make a privileged will. A mariner serving in a military expedition but not being at sea is considered as a soldier and can make a privileged will. So these are the three illustrations which I have given about a privileged will. Now, what is the important feature of this privileged will? Now, normally we come across of a situation that will has to be drafted so that it can be conveyed. But here, both options are available to you, that you can have a verbal will, that it must be declared before two witnesses present at the same time. So a soldier is there, is likely to die in an expedition. He says to some of his friends that I have got a property with me in itself that I would like to divide into two sons. Elder will get 25%, the younger will get 25%, 50% will go to my wife. So this is a mere verbal declaration. This is being called as a privileged will for a soldier in itself. So it can be verbal, it can be written. He may not write because he's having a gun in his hand. He cannot write anything in this particular matter. So he can write either by himself, or he can ask another person also to write in itself. So if it is writing by the testator, neither the signature of the testator is necessary or attestation is being required, which is the normal feature which is required to be present in all other unprivileged wills are concerned. Now, if it is written by some other persons also, signature of the testator is necessary unless it is shown that it was written under a direction, he recognized it as a will. However, a attestation is also not required. So the basic point that what you need to understand in case of airman, soldier, or mariner, if they are on a mission in itself, either they can have a verbal will that will be considered as a final legal will. If it is written by the testator, that is also a valid will. And the third is written by, dictated by him, but written by another person is concerned, still it will be called as a written will, legal will in the technical sense. Now, what are the instructions to prepare will also constitute a will? So simply saying that you draft a will and these points you should add it up, and once that will is being prepared, that will be considered as a will in itself. Now, verbal instructions also constitute a will, provided such instructions were given in the presence of two witnesses, such instructions were reduced in writing, and he dies before the instrument is being prepared. So this is what the privileged will that you need to know about. Now, all other wills which we are going to talk about come under the category of unprivileged wills, wherein the signature of the testator is required, intention behind the signature is being required, attestation is also being required. Each witness must have seen the testator's signature or affix the mark in itself. Other person sign the will in the testator's presence is also required. Each witness must have received from testator a personal acknowledgement of his signature or mark and the signature of some other person. So these are the normal qualifications which we have seen just now are required to remain present over here in itself. Now, in case of unprivileged will, which I have just mentioned about, so this point I will skip it out because of the non-availability of time for me in itself. So I will just move and go to the straight away. The second important part of the kind of the will in itself, which is technical sense, we call it as an unprivileged will. So that is over now. non-competitive or oral will is being there. This oral will is not acceptable to the Indian Succession Act except soldiers, sailors, and airmen. So airmen are entitled to have this oral will. Other than that, no common man can have a verbal will. This will is being called as non-competitive or oral will. Then holograph will is also being there. Now, all these wills which we are going to talk about are the precedents which have been emanating out of the various High Court and Supreme Court decisions, and they have accepted these particular contents of the will in this particular format, and that is the reason why these kinds of wills have emerged in various books, those we normally come across of. Now, this is a will written in the testator's own handwriting, and would also go to show he is fully aware and conscious of making the will. Now, when the will is neither typewritten or in a word format, but the person testator writes in his own handwriting, then in that particular case, the matter is a little bit different. But when it is written by the beneficiary in itself, adverse inference may be drawn by the courts in itself. That is what the Ghanasham Sundari versus Chinnamal's case ultimately talked about. The next kind of will is the inofficious will. Now, this is the will that is being given in an extraordinary way because this normally in our Marathi language, it is being called a Chakramaditya will in itself. In technical sense, that when a person dies or makes a will in itself, it normally gives the property to the legal heir, to the wife, or to the children or daughters, as the case may be, son, daughter, or grandchildren, as the case may be. But here, if the will is being made by the testator, not keeping with the natural affection and moral duty, and ultimately has bequeathed his property to a stranger or to the complete exclusion of his wife, her husband, children, or other relatives, the will is being called as inofficious will in itself. It is a valid will in the eyes of law. That is what a number of decisions ultimately courts have held about. Then comes the next will, mutual or reciprocal wills. Now here two persons are said to be making mutual wills when they confer reciprocal benefits upon each other under their will. A mutual will is one where two persons give each other similar rights in each other's property. For example, A bequeaths all his property to B, B makes will giving all property to A. So this is being called as mutual will in itself. So mutual will is another important feature which you need to remember. Now come the joint wills. When one will of two persons is being made. A joint will is defined as a will made by two testators contained in a single document, duly executed by the each testator, disposing of their separate properties or their joint properties. So once these are being covered up, then in that case, it becomes a joint will. Normally, the will prepared by husband and wife falls in this particular category. Contingent or conditional will. Now, when a particular event is to take place, on the basis of that only the property is to be transferred, then in that case, should anything happen to me during the passage, my train fare from Mumbai to Delhi in itself, then in that case, the property should devolve upon so and so person. If that event happens, the will be perfect. But if that event doesn't happen, then the will is not to be considered as will. Then duplicate will is being there. A duplicate will is one which two or more copies are made of the same will, of the two or more copies are being made. If such copy is signed by the testator, it can operate as an original will, where will is executed in duplicate, one of which is to the testator has to retain, while the other is deposited with the custody of another. The destruction by the testator of the original will, which was in testator's possession, revokes the will. Conduct of the testator has been given more importance in this particular type of will. So if the testator destroys the will is said to be revoked. Now comes the digital will. Now digital will is the comparatively latest concept in itself. And this is being required for various reasons, because you might be owning certain property, because digital will is there in United States of America. Over a period of time, it will percolate in India too, because in each state there is a law, revised uniform fiduciary access to digital assets act in itself. And under this particular law, one person could be having so many email accounts: Gmail, Microsoft Outlook, Yahoo, etc., social networking account, Twitter, Facebook, LinkedIn, etc., photograph and video sharing account, YouTube, Instagram, TikTok, Snapchats, etc., cloud storage account, Google Cloud, iCloud, Dropbox, Microsoft OneDrive, then online purchasing account, Amazon, Venmo, PayPal, eBay, etc., airline, hostel rewards, and personal website. So these are the digital assets that I'm just mentioning about. But in addition to that, there are many other digital assets which cannot be seen. For example, type of cryptocurrency. Now, in case of cryptocurrency, there is neither it can be called as a movable property or immovable property, as it is in the electronic format only. So you have to dispose it off with the help of this particular will, and that once the property is being incorporated in that, it is being called as a digital will. Once that is being done, the items which are just highlighted in itself, you can add any much more items to that particular category in itself. Now, the next will is a living will. Now, much has been talked about this particular living will. This living will comparatively doesn't confer any special rights. It confers certain special rights on the doctors only, not to the a person who is a testator or his relatives and as a result of which, during the lifetime, because there are certain cases which you may come across of, that a person may go into the vegetative state and will not be able to express wishes regarding his preferences regarding medical treatment to be given. He can be put on ventilator also, and in that particular case, lot of agony to the family members as well as to the testator may cause. So in this particular situation, can he write that after a certain period of time, there should not be any medical treatment that should be given to the deceased person in itself, and instead of that, the medical treatment should be withdrawn. So in that particular case, the situation will be that can such type of clause be added? That is the major issue. Supreme Court in one of the cases has pointed out that a team of doctors can think about that. There was a writ of mandamus also on this particular count, and the Supreme Court, in a very rarest to rare cases in itself, have conferred right on the doctors to stop the treatment in itself. So in one case, after a period of 21 years of problem in itself, in the health in itself, the lady was in coma. Ultimately, her life was put to rest in itself. So the question is, can mercy killing be allowed under the living will category? Answer is no. In that particular case, the living will only will give you a picture about what can be done about this, nothing beyond that in itself. So only medical treatment can be stopped, not only by the testator or by their relatives, but it can be stopped exclusively by the doctors itself. Then videography can be carried out in order to ensure that whatever will that cannot be challenged by any person in itself, you can just read out the entire will in front of the video in itself, and then put your signature in front of the camera in itself. The testators put their signature, the witnesses put their signature, the medical certificate is being handed over by the medical practitioner, that is also brought on record in the camera. That will is being called as a video will. So far, that has not taken a momentum at present, but videography is being considered as a documentary evidence to prove the will in itself in the technical sense. Then another will is being there, which is for the property outside India in itself. Now here, a general feature which we need to learn here, that the will is required to be prepared country-wise. It is that if it is in India, it is outside India. For every country, if you are having different properties, because local laws will be different in each and every country, and you have to prepare the will in consonance with the provisions laid down in that particular country. So as a result of which, if a person happens to be having various kinds of assets in several countries in itself, several wills will have to be prepared, and that property only required to be specified in that particular will in itself. Once that is being done, compliance with the local laws will be carried out. You can reduce your tax consequences. Distribution of properties will be faster. Different asset types can be covered up. Protection to against challenges also can be there, and administration also will be comparatively easy. Now, one more aspect, which is the major aspect that I just wanted to cover, and I will ask the moderator whether I can continue, but this will be more feature that I would like to cover. Now, while drafting the will, how it should be drafted? First point has to be the personal information. It should specify the testator's name, what is his name, what is his father's name, what is his home address, what is the date of birth, age, etc. Religion also is required to be specified, because for every religion, comparatively the will format is different in itself. Then the second important point that is required to be specified is the declaration of date, when this particular will is being prepared, clearly mentioning that the will preparation date is vital in itself. Then free will, that free mind, etc. is being there. While creating a will, one should mention that he is making this legal document by free will and not under the influence or pressure of any person. He has a sound health and fit medically to prepare the wealth in itself. The implementation to take place after death is being concerned, because this is the major issue that that is required to be covered. The testator has to specify in an ambiguous word the contents of this will. Shall diamonds, gold, silver ornaments with exact specification, weight information, virtual asset, demat accounts, etc. is required to be specified so far as the things are concerned. So assets and beneficiaries are covered over here is the major issue that you need to understand. Then executor's details are required to be covered up. A will requires an executor who implements it. Therefore, testator must mention the executor's name, address, relationship with the executor, age, etc. If not, beneficiaries will have to apply to the court for administration. Location of video is required to be specified by the concerned person, and that is how the residuary legatee is required to be specified. This is called as a residuary clause, because you may specify A property to be given to B, B property to be given to C, and all the list can be made it out. But while listing out the asset, some asset may not be incorporated in the will. So that residuary clause has to be there, and residuary legatee also has to be there. Once it is being there, the matter will be said to be over in itself. Then the registration is required to be carried out. Registration is advisable. Signature of the testator is equally prominently important. That has to be done in presence of at least two witnesses. You can have more than two, but at least two. Then the signature of the two witnesses has to be there. Their addresses, Aadhaar card number, PAN number, father's name, full name, age, etc. is required to be carried out. The age of the witnesses, as far as possible, should be less than that of the testator in itself. Medical practitioner certificate is also required to be carried out. So this is the point where 100 slide is being over. So I will ask our Chandrakantji whether should I continue or we would like, because the time is already over, and as per institute's norm, we have to conclude at particular point of time. If you are saying yes, I have to share one small story.
Yes, sir.
So a small story I would like to share, and then I will conclude. A similar hall was there where participants had gathered in optim number, but the place was not in India. It was in United States of America. All white-skinned people were there. A lecturer was being invited to deliver a lecture for 2 hours. The lecturer came, started delivering a lecture. 2 hours passed, but the lecturer did not stop. He continued. The whitish faces which were there, which were the participants, started becoming pinkish, indicating that some anger was growing up. But the lecturer did not stop. He continued further. Then the patience of the participants started drying up and the pinkish faces started becoming reddish, indicating that the anger was on a boiling point. But the lecturer did not listen. He still continued. Then a person sitting on the last bench got up, took out a revolver from his pocket, looked with red face and potato type eyes toward the dais. And the lecturer also looked at and started marching toward the dais. The lecturer saw him and said that, Arey, you are having a red face, marching toward the dais, having a revolver in your hand. Are you going to kill me? Then said, don't worry, I'm going to conclude. Take your seat. I'm going to conclude in 2 minutes of time. Then the person said, no, I'm still coming forward. Then the concerned lecturer said, are you going to kill me during the course of lecture so that I should never deliver a lecture in future? Then he said, no, don't worry. I am not going to kill you, but I am going to kill those who invited over here in itself. So I don't want Chandrakant ji, Shekhar ji, then the Sharma ji, Hina Gupta ji, Anjali Sharma ji, Mayank ji, and similar other Shekhar also to be the victim of my crossing the limit of 2 hours in itself. And that being the reason, I am really grateful to all of you for your support in itself. God bless you all. Thanks a ton. I am grateful to you all for the learned attendees. Thanks a lot. Thanks a ton. Chandrakant ji, over to you.
Yes, sir. Thank you, sir, for your wonderful presentation on the intricacies of will. What I have understood for the last 2 hours is that the first thing is that we have to save the family disputes first, because that is very important. And then better estate planning. More importantly, the definitions and the explanations that you have given, sir, was very wonderful, especially the misconceptions that we carry between the beneficiaries and nominees. Many a times the nominees feel that they have all the rights for the whatever the property or the balances that have been left out by the deceased. But then you have made the points very clear. You have also, by hearing to your lecture, I feel that one should have a stressful, not to have a stressful life, rather than we put a proper map after you leave this world, so that the whatever wish that you had when you had in this world is properly been executed after your decease. So this is what I felt, and very wonderful presentation, sir. There are a few questions I think we should take it up very quickly within 5 to 10 minutes so that we can wind it up. Some of the questions have been already answered by you in your presentation, but few of them I think we should take it. There are some questions which are very repeated. This one is, can one make a will of an ancestral property in case of HUF?
That's a very good point that Chandrakant ji, I have jotted down in the slides in itself, but I could not do it justice to it because of the paucity of time, because my original lecture is always for 3 hours. But since this lecture was limited to 2 hours, so I had to skip out certain side. But it's a very, very intelligent question that has been made it out, that once you are having an ancestral property, then it becomes a Hindu undivided family property, and only your share you can transfer it to your legal heirs are concerned. It is not that the entire property can be transferred. For example, you are having a house in itself which is inherited by you, and you are having 1/6 share. So you can transfer only 1/6 share of your choice to any person of your choice. It is not necessary that it should be given equally in itself. You can transfer the share to your wife exclusively to the exclusion of your sons and daughters are concerned. But it's a very good, intelligent query that has been raised by the participant. Thank you.
Yes, sir. Can a legal heir certificate be modified?
Yes, the legal heir certificate is normally given by the Tahsildars, and it is based on the application that has been made by you. So you can have n number of legal heirship certificates. There is no bar on that.
Oh.
Every time you go there, and now you know that how Tahsildars are issuing certificates. So in that case, there should not be any problem. Only the rubber stamp is being affixed by the Tahsildars on the application. They are just copying down. They are just verbatim copying the technical sense and issuing the certificate. So there is no complication involved in this. As like probate, you might foresee some difficulties.
Whether husband and wife, whether they can jointly execute a will for their individual properties.
For the immovable property.
Yeah. Maybe
Why not?
movable, immovable.
That is also possible because joint will is the will in one document, they can do that. There is no need to have two separate documents. There is a special feature Supreme Court has accepted that husband and wife or two like-minded twins or two good friends can jot down one will in one document, and they can have their choice of desire, whatever they wish to do. So husband and wife is a common feature which is seen in joint wills.
There's another question. If the properties are spread across the states, then in which state the will should be executed and registered?
No, Indian Registration Act is there. So in that particular case, sky is the limit for the country in itself. You can register anywhere, normally the place where you normally stay. That is the place where you are expected to register. But if that is not there, but you are having different places of business in itself in different parts of state, then it is your choice that you can get it registered in any state. So normally it should be the place where you normally reside. That is the place. But if
Suppose
you are having multiple places.
Correct. Sir, suppose I am staying in Bangalore and my property is in Mumbai. And as you said that in Mumbai, probate has to be executed.
Yes.
Then whether that can be executed in Bangalore?
No, location of the property is very important everywhere because probate is required in Mumbai, Kolkata, and Chennai only. So in that case, if the location of the property is in Mumbai, probate will be required. There is no option for that.
Oh, fine. These were the some of the what I have jotted down was these are the questions been asked by the there are a lot of questions, but most of the questions are which you have already answered in your presentation. So I thought that I should not take it and waste increase the time because it will be repetitive this thing.
Chandrakantji, 1 second. I
Yeah.
have not thanked you for introducing me the way in which you have done it. No other person would have done in such a proficient and decent way that what you have done. So thank you so much. I have not thanked you in the initial stages.
No problem, sir. I am always your junior and you are my senior, sir.
That is
We
true, but
require
after
your
all,
blessings more
your
rather than
efforts
your
are very
this
important.
thing, appreciation. But anyway, sir, it was a very nice presentation. There is a request been all many participants are giving that they wanted to share, they wanted to have your PPT, but I don't know, but how it can be. And if there are so many questions been coming up, you have already shared your email. Here, the participants are requested to take the email, write it down, and then you can always put your question through emails. And I think if sir is having time, he can answer it. It's not an issue.
Yes, that can be done at any point of time. There are queries are always welcome. No problem.
Yes. So as far as PPT is concerned, we will put forth the same.
I will share it with the institute. I will share it with the
and
institute.
I will also put forth to them that money,
Yes.
all the participants were requiring the PPT, whether it can be shared. If it is yes, I think they will share it to you directly. Okay. With this, I would like to thank the committee for giving me the opportunity to be the moderator of this session. At the same time, I would also like to thank from the committee and from the institute point of view. It is our own colleague who has presented the topic today and has given us a wonderful presentation. We will see it, Dr. Dilip Sadbhai. On behalf of all of us, we are thanking you for your wonderful presentation as well as the time that you have shared and the way you have explained it. I hope it is one of the most useful topic that we have perceived today, apart from our regular topics that we dealt with. With this, I would like to thank all the participants for joining us and the faculty that we have today. Thank you. Thank you for all the time and the presentation that we had today. With this, I thank all of you. Thank you, sir, and good night. Yes, sir.
Recording stopped.